Hi, my name is Mary Mukoma. Karibu sana to Sheria Briefs, where we make the law practical. Let's talk about some of the most important people in our lives, our parents. Now, unfortunately, there has been a lot of cases about dementia and other mental illnesses affecting our elderly group, our parents especially, and for some of us, our grandparents. Sometimes you feel helpless and yet you really care about them and you cannot be with them throughout because perhaps you have your own responsibilities. There is a solution that perhaps you may need to consider if you're facing such an unfortunate position. The Mental Health Act gives us an opportunity to make an application in such cases, and you can petition to the court for guardianship. Let me explain what guardianship is all about. Now, where somebody is facing a mental illness, not all kinds of illnesses, but illnesses that do not allow them to function in various capacities, such as decision making, you are allowed to then make an application for guardianship, either as a relative or as a caregiver. Now, the petition that is supposed to be filed in court is accompanied by an affidavit. This affidavit will be signed by the recommended caregiver or the recommended guardian, and it will also be accompanied by a list of all properties belonging to this parent or this person facing this mental illness or a challenge, especially dementia. You will also be required to list all the relatives that are concerned, especially the dependents, the children, and if there is a spouse, that spouse must also be recognized. Then you will also be required to explain why you feel that it is important for the court to appoint you as a guardian or whoever else is being appointed. Now, the court will need to see record of the mental illness, and the best place to start is a diagnosis done by a doctor, a medical practitioner that meets the qualifications according to the Mental Illness Act. So, Mental Health Act, apologies. So you will have a diagnosis and you will have records of treatment, and in some cases where our patients are already admitted, you can also give the admission letter or documents to prove that the person is undergoing medication. Upon your appointment as a guardian, there are things that you will not be able to do, of course. For example, you cannot sell the property belonging to the patient, you cannot put it under mortgage or a charge with a bank, and things like those. But you will be allowed and you will have the powers to take care of the health of that person. You will indeed take care of the living conditions, the therapy or medication that is needed. And if there is an income generating activity, say a business, you will be allowed to operate it. And you will also be allowed to take care of the dependents that were depending on this patient. This is important because you will bear me witness that once our parents start facing dementia, there are people that take advantage of their position and even have them sign checks or give money or send money through M-Pesa and other channels, even when they really know that they are not supposed to be receiving these monies. So it is important for you to take the next step, talk to your family. If you feel this is very important for your parents or for your loved ones, it is something to consider. It will preserve whatever your parents have worked hard for. If this is an option that you wish to consider, have a meeting with your parents, your loved ones, your siblings, and consider it, because at the end of the day, it is our responsibility to take care of our parents who took care of us when we couldn't. It is also our responsibility to make sure that people are not taking advantage of them and that their estate is preserved. Thank you. Please subscribe. My name is Mary Mukoma.